Hello, and today I want to talk to you about the legal challenges to managing flood risk. So let's begin with the statutory regimes that are in place and how they function when we're looking at the management of flood risk. Well, the main act that is at the focus of flood management is the Flood and Water Management Act 2010. And essentially, what this act does is it divides responsibilities between committees and authorities, and also imposes a duty on these institutions, on these legal characters, to cooperate with each other. Now, the interesting thing about this act is that it was made as a response to how government had dealt with floods in the past, because there was a lot of criticism that they didn't work together in partnership. There was a lot of confusion, which leads to inefficiency and just an inadequate way of managing flood risk. In addition to that, we have things like Planning Regulation, Land Drainage Act, Water Resources Act, and they monitor very specific aspects of flood management. And they all are pretty individual. So the sense we get from the statutory regimes that exist is that there's no overarching statutory regime. So what the main legal challenge arising from this is that there needs to be some kind of clarity as to how flood management, will be managed in the future, because there's no clarity, there's no kind of defining act. It's all pretty separate and individual, and it can get quite confusing. So this is going to be exacerbated, right? This issue of a lack of clarity, and it's going to be exacerbated by three main types of claims that may arise in the future, and some which already have potential to arise today and have arisen in the past. So there are three basic categories we're going to look at, which is flooding in relation to neighbours, flooding in relation to climate change, and flooding in relation to public authorities. So what I mean by flooding in relation to neighbours, this is where neighbours have acted in a particular way or have done something which has either increased the effect that you as a property owner have had by flooding, or has actually caused the flooding in itself. Now, the way this is dealt with in law is through tort law. And I have videos on Nuisance and Rylands and Fletchers, because this is the area of law that concerns where a neighbour has either caused or exacerbated the effects of flooding. Now, the general principle is, though, if the flood has arisen out of a natural occurrence, you can't sue under tort law. There's nothing you can do under it. But this position was clarified in the case of Rylands and Fletcher, which said if you bring something onto your land which is non-natural and it escapes and it causes this damage, then you can sue. And this already demonstrates the court's let's say willingness and the way they've evolved in the pursuit of justice to ensure justice is achieved. And you can see throughout all different areas of laws, in the pursuit of justice, courts are willing to make rules and previous previous common law ideas more flexible. Now, a key case which also shows how courts have evolved in their approach to dealing with flooding caused or exacerbated by neighbours is in the case of Leakey and National Trust 1980. Here, the general principle that arose in this case was that the defendant was found liable for a naturally occurring hazard on the neighbour's land. And this was because the court said if you are aware of the danger or have failed to act within reasonable prudence to remove the hazard, then you can be held liable. So again, you're seeing courts willing to impose more and more duties on the neighbours so as to ensure you as a property owner are not having to suffer. It's a balancing act, essentially. So this is a potential growth area as we see more and more floods caused by climate change and just the general changing environment of our world. This is the first growth area through tort law, through Nuisance and Rylands and Fletchers, and already we've seen some growth areas, as I've showed you with examples of Ryland and Fletcher and Leakey and National Trust 1980. So moving on, the second key growth area for claims can arise through something called climate change litigation. Now, this is a largely academic area, but it could potentially be a growth area, so it's an interesting thing to consider. So the issue is whether you can bring a claim onto a polluter or a business or an individual for the impact they've had on climate change, which has then gone and caused some kind of natural hazard which has caused you some kind of damage, either to you personally or to your property, something along those lines. As you can already see, the reason why this is an academic topic is because the main problem is a causation problem. This whole idea of but for, proving the act that was the Novus New Intervening Act, these are all causation problems that relate to this. But it's still a growing area, and it's still something to keep in mind, and it will be a legal challenge where we're looking at cases of flooding. Perhaps through judicial activism, even though that's quite rare in this country, and parliamentary response from pressures from the public, there may be a way of dealing with this, or to get scientists and parliamentarians in a room just discussing what is the best way to go about this, put some economists in to balance the costs and benefits. This is how other areas have developed, so potentially in another 30 years time that could be something we're looking at. Or another option that I thought of is you might consider imposing a strict liability on someone you can prove has contributed to climate change to a reasonable degree. If you can show that, then you might say there's a strict liability that the flood that occurs in Area X. I haven't thought through this idea, but it's another way. Or perhaps you want to bring in the criminal justice system as a way of criminalizing some acts which affect climate change. It's interesting. And also, as I showed you in the case of Nuisance and Rylands and Fletchers, in the past, we can look to the past to see how the future is going to go. And in asbestos cases, the courts have become more lenient with the rules of causation in pursuit of justice. They want to deliver justice. So you can see that they might be willing to let loose on the causation in terms of climate change litigation in order to do so. And the final area of growth area, with looking at legal challenges and legal claims within the flooding realm, is looking at challenging public authorities. Now, this is not a straight out tort area. This is more of a public law area, and the idea is to question the sufficiency and adequacy of public action. And you might want to do this through judicial review. But judicial review has no real there's no real relief remedy provided at the end. There will be a judgment saying this was not a satisfactory action that the public authorities have taken. So from there, it would take a bit more time for Parliament to respond to the judicial review and say, okay, as a result, we're going to pass this act. As we said, there's already too much division between the statutory regimes that already exist and a lack of clarity. And then this might lead to, new floodgates. There's a pun there, but new floodgates in relation to civil claims. So this is another growing idea, and this could potentially also be. What is interesting about flooding is because it's an area of environmental law that you can see becoming quite commercialized and becoming really quite big in the future. I just thought I'll share some knowledge with you that I had, and I hope you enjoyed.